Last but certainly not least this afternoon is Mr. Glen Gerding. Glen is the North Carolina Appellate Defender in Durham, North Carolina. His office represents people from across North Carolina in the appellate courts after a criminal conviction if they can't afford an attorney. Before becoming the head of the Office of the Appellate Defender, Glen was in private practice, mainly representing indigent people both at trial and on appeal in criminal cases. He has also served as an assistant public defender, and he served for 6 years on active duty in the U.S. Navy JAG Corps. Glen still serves in the Navy Reserve, holding the rank of captain. Glen has challenged North Carolina's premises and internet restrictions and satellite-based monitoring program in the trial courts and on appeal. He partnered with Paul Dubling to litigate the constitutional challenge to North Carolina's premises restrictions in Does v. Cooper. But most notably, he represented Lester Packingham, Jr. in the trial court, North Carolina Court of Appeals, and the United States Supreme Court in Packingham v. North Carolina, another of our really important wins. In his presentation, Everyday Champions, Glen will be sharing his observations of developments in advocacy for registered individuals since he began his work. Welcome back, Glen. It's great to have you as a presenter again. No sound, Glen. Hang on.
Can everybody hear me now?
That's better. Yes, thanks.
Good afternoon, everybody. Thank you for the opportunity to speak to you today. I really appreciate the chance. It certainly is an honor and a privilege for me to speak to this group. I wish we could all be down the road in Raleigh to be together and to share this opportunity, but certainly circumstances have come up and we're doing the best we can. So I'd like to get started today by talking with you about you and our advocacy for people as everyday champions. I remember when I first started as a criminal defense attorney over 20 years ago, I joined the National Association for Criminal Defense Lawyers, and they had a monthly magazine that would come out. And the name of the magazine was The Champion. And at the time, I thought that the name was a bit unusual because for anybody that's ever practiced much criminal defense, you certainly know that you actually don't win that many cases. And it finally hit me that the term champion didn't refer to us as attorneys always winning our cases, but what it referred to was the fact that we would champion for our clients, that we would stand up and fight for them. And a champion is a person who fights or argues for a cause on behalf of someone else. They are an advocate, they're a fighter, they're a defender, a proponent, and a protector. And over the past 25 years as a defense attorney, I've come to understand that it isn't always about winning, and sometimes you have to define what it means to win, but it is about being a champion, to stand up for someone, to help them, and to protect them. And that as a champion, this is something we should do on a daily basis. It is something that should be commonplace. And as I have worked in this area and advocated for people on the registry, I have run into countless people like yourselves who are everyday champions. You don't have to be an attorney to be a champion. You could be a family member, you could be someone's friend, you could be a person who is required to register. You could be part of an advocacy group. I was so impressed with NARSOL and their efforts nationally and at the state levels to help people on the registries, to help get back on their feet, to help get out from under laws that were restrictive and punitive. And the level of advocacy and the champions that the people are at NARSOL has impressed me since I first started working with them a number of years ago. So let me tell you how I got here, and then I will go through some other aspects of my practice and some suggestions for how you can be an everyday champion. Back in 2009, I was in private practice. I was a courtroom lawyer. I did some appellate work, but I was going to court just about every day, representing clients charged with misdemeanors and felonies. And I just happened to be in court one day when one of the judges was needing to find an attorney to appoint and to represent a person who had been charged. The judge looked over at me and said, "Mr. Gerding, I need you to represent this man, and I'm going to assign you to his case." Well, at that point, I didn't even know what he was charged with. I came to find out that he was a person who was registered, and he had been charged with violating North Carolina's premises restrictions. And the law was only about a year old at that point, and so I really didn't even know that it was a law. So I began to speak with this man and find out what he had been charged with, and apparently what had happened was he went to church. He had attended church, and North Carolina's premises law at the time applied to places including churches. There had been no allegations that he had engaged in any kind of misconduct. He was there with the permission of the pastor. He was known to the congregation, and he had simply been at church, and someone found out that he was on the registry and reported him to the sheriffs. That day in court, I was speaking with the district attorney about the case, and I expressed to her my concern about a person who was charged with a criminal offense for going to church, and she said to me, "Would you want to sit beside that man in the pew at church?" And at that moment, it struck me just how awful and horrible the restrictions were for people who are on the registry. This man had been trying to get his life back together, and he was charged with a felony for going to church. Fortunately, I was able, along with some assistance from our local ACLU, to put together a motion to challenge that statute. And our local judge declared the statute unconstitutional and dismissed the charge. In that case, the state failed to appeal the case properly, and it never got into our appellate courts. But there were several other cases that followed that I was involved with, involving clients who went to parks or a county fair. Ultimately, our state appellate courts did not resolve favorably the constitutionality of that statute. And so I was able to partner with Paul Dubling, who I think you've heard earlier today or yesterday, and we litigated Doe v. Stein. I think it's also called Doe v. Cooper. And we were able to convince the district court in North Carolina that the statute was unconstitutional. I've also been involved in, as was mentioned, a challenge to North Carolina's internet restrictions, and that was in State versus Packingham. And that case did go to the United States Supreme Court. And I've also been involved in litigating the satellite-based monitoring, which is basically the GPS tracker which is attached to people's legs so that the state can track them and monitor them. And that has been a case called North Carolina versus Grady. So I'm going to give you a slight detour and talk about State versus Grady, just so you have a little bit of an update about what my office is doing and how we're trying to be a champion for people in our state. So in North Carolina, we have a fairly broad statute that requires most people who are registered sex offenders to have a GPS tracker attached to their leg. Anybody who has been classified as a recidivist, anybody who has committed what the statute calls an aggravated offense, or anyone who has committed an offense against a minor, can have that GPS attached to their leg for life. That statute went into effect around 2008, and initial and early challenges to the statute dealt with whether it was an ex post facto violation. There weren't even really any challenges to whether it was a search. But around 2014, there was an attorney who decided that there had been some new U.S. Supreme Court case law which would maybe make this statute subject to challenge as an unconstitutional search. And so the attorney was able to litigate the case through the North Carolina appellate courts to the U.S. Supreme Court. And in Grady versus North Carolina, the U.S. Supreme Court ruled in March of 2015 that having that GPS device attached to a person's leg is a search for purposes of the Fourth Amendment. The United States Supreme Court did not say if it is constitutional or not. All they said was it is a search. And so they remanded the case back to North Carolina. It was remanded back to the trial courts. And the trial judge looked at the case again and again ordered Mr. Grady to have to wear a GPS tracker on his leg for the rest of his life. At that point, my office represented Mr. Grady, and we appealed the case to the North Carolina Court of Appeals. At that point, the North Carolina Court of Appeals got the message. They understood that it was a search because the U.S. Supreme Court had told them that. And they understood the arguments that we made about the restrictive nature of it and the invasion of privacy that was brought about by this GPS tracker. Of course, the state appealed that case to the North Carolina Supreme Court. And our North Carolina Supreme Court has since addressed that. But in the meantime, the North Carolina Court of Appeals had an opportunity to review a number of other cases, and they also held that the GPS tracker was unconstitutional. Now, one of the aspects of the cases was that the Court of Appeals did not say the statute was unconstitutional on its face. And what that means is they did not say it was unconstitutional for everybody. All they did was say, as applied to this individual, this is unconstitutional. So when the case got to the North Carolina Supreme Court, at that point, we were able to convince the North Carolina Supreme Court that the law was unconstitutional for everyone and not just Mr. Grady. But what the North Carolina Supreme Court did, they limited their holding to people who are classified as a recidivist and to people that are not on some kind of parole or post-release supervision. What they did with the other cases that had been pending at the North Carolina Court of Appeals was to remand those cases to the North Carolina Court of Appeals to be reconsidered in light of their opinion in State versus Grady. So now we are again re-arguing cases at the Court of Appeals, trying to advocate for our clients, trying to champion for their rights, trying to show the Court of Appeals that these statutes on their face are unconstitutional. We're in the middle of that right now, and we have not prevailed on a facial challenge again in the Court of Appeals, but the cases are back at the North Carolina Supreme Court. So stay tuned. Maybe next year at the conference, I can give you an update on that, and it might be favorable. One of the aspects of the North Carolina Supreme Court case that is very important is that the North Carolina Supreme Court did not accept the state's argument that the special needs doctrine applies for GPS tracking of people on the registry. The special needs doctrine is an exception that the United States Supreme Court has created to the Fourth Amendment's requirement for a warrant. And the special needs doctrine has been applied to such things as drug testing for high school athletes, or drug testing for train engineers who have an accident while they're in charge of a train. Areas where a search might be done for purposes other than for criminal prosecution. That is a good thing that our Supreme Court rejected the state's argument, because at that point we knew that the state was going to have to show that this was not an invasion of privacy and also show that this program was somehow effective. But they weren't able to do that. And the North Carolina Supreme Court recognized that the privacy rights of people on the registry are just the same as people who are not on the registry. And that was an important point because the state had been arguing in the trial court, in the Court of Appeals, and in the Supreme Court even, that a person on the registry has a reduced interest in privacy. The North Carolina Supreme Court rejected that and said, no, people on the registry have the same right to privacy that people who are not on the registry have. They also said that GPS tracking is a substantial invasion of privacy. The state had argued that having a bracelet on your leg that tracks you 24 hours a day, 7 days a week, wherever you go, was not an invasion of privacy. The state said this was no different than carrying a cell phone in your pocket. Fortunately, our Supreme Court did not accept that. They recognized that the device is physically attached to a person's leg. They recognized that the device does more than just show the location. It does show your location, but it shows that you went to a church. It shows that you went to a store. It shows what kind of churches or what kind of stores you go to. So it shows more than just a location. It actually shows information about you. It's continuous. They recognized that this was not a search that only took place once or even over a 30-day period of time, but it was continuous and it was for a lifetime. There was no opportunity for a person to argue that it shouldn't be applied to him. So there was no individualized consideration that might be appropriate for a particular person to not have to wear the tracker. The state also was not able to show any evidence of recidivism rates or efficacy. Efficacy means the deterrent effect of the GPS tracking. And so based on those things, the North Carolina Supreme Court said that it was unconstitutional. I'd like to move on now and talk to you a little bit about what I have observed about successful champions over the past 25 years and what they have done to champion for their clients. The three things that I'd like to talk about today are organizing, strategizing, and persevering. Because as I have looked at not just my own practice, but at organizations like NARSOL, I've recognized the qualities that have brought success to people as they champion for their clients and for their cause. Champions organize. I put NARSOL here at the top. I think what they have done as an organization has been phenomenal. They have brought together a variety of stakeholders. They have brought together a variety of people throughout this process and around the country. They haven't limited themselves just to people who might be on the registry, but have included their friends, have included their families, have included attorneys. They've included psychologists. They've included experts. They have brought together people from around the country from a variety of backgrounds to champion. They have done this through an organization that, as you have seen from this two-day conference, can pull off great things. Partnerships are also important. Partnerships between your organization and the criminal defense bar, partnerships between your organization and faith groups, partnerships between your organization and community groups that advocate for less fortunate people. Allies. Allies are part of your organizational process. You need to find out who they are, and you need to organize with them. You need to figure out who the thought leaders are in your community. You need to figure out who the thought leaders are in your state. And by thought leader, I mean a person who has put themselves out into the public, into the mainstream, into online platforms, into the academic research. People who have put ideas out for reform or for change or for supporting marginalized groups and populations. Thought leaders are the people who are able to reach the most people in your state or in your area. You need to organize with them. You need to organize your data. You need to have a handle on what your state data reflects. How many people are on your registry? How many of those people are men? How many are women? How many are African American? How many are white? What does your data show as far as the increase in numbers on the registry? Has it gone up? Has it gone down? One of the most important people you could have in your organization is someone who is able to find that data, who is able to manipulate the data into a form that it is presentable and is able to show it to people in a way that can be understood. Successful organizations also monitor legislative action. And legislative action, as we all know, comes in waves and it comes in cycles, but you always need to be closely paying attention to your legislature, your General Assembly, whatever you call it in your state, to know what the status of legislation is at any time. And you need to be organized in a way to not only know about it, but also to respond to it. I've seen efforts here in North Carolina that have been very impressive. We have several people with the North Carolina NARSOL who regularly are reviewing bills and enactments from our General Assembly. And I get regular emails saying, Glenn, there's a bill that's come up. We need your input on this. What do you think about this? Is this something that could be challenged as unconstitutional? How could this be changed? How could it be defeated? And I've appreciated having those emails because I have not had the time to be that person that monitors our legislature, but I am happy to provide input. And so in a way, you can organize your group or yourself even to monitor legislative action. It will help you to be a better champion. Champion Strategize. And I would like you to ask yourself individually and as an organization, what do you hope to accomplish? Not necessarily what can you accomplish, but what do you hope to accomplish? Because you need to set your goals high, you need to have hope, and you need to strive for the highest opportunity possible. That usually involves long-range planning. And long-range planning might be, we need to have the registry disestablished. We need to pull back on the registry. We need to eliminate restrictions. Those are big goals. Those are long-term goals. Those are the things that you hope to accomplish. But you need to put those down on paper, and you need to have those goals in mind to guide you as you're going through your day-to-day efforts. You need to strategize on how you accomplish it. What are your short-term goals to get to that long-term goal? And what are your priorities? I was listening to the presentation before lunch from the ACLU of Michigan, and one of the questions was about challenging, how is it decided, or who decides what is challenged or how an issue is challenged? And that made me think of having priorities. It may be that in your state, your priority is to reduce residence restrictions. It may be that the priority in your state is to eliminate premises restrictions. It may be the priority in your state is to make an ex post facto challenge. And your priorities may be determined by what is actually practical. So it's going to be unique wherever you are, what your priorities are. I know the priorities of the national organization of NARSOL is to help people to reduce suffering, to eliminate the registry and restrictions to the greatest extent possible. But we all know that at the state level, you need to set your priorities for what can be done in a realistic way. Strategy also includes details, small details, like the words that you use and the words that you choose to use in referring to things. In my presentation about the GPS tracker, I call that a GPS tracker. Our law calls it a satellite-based monitoring device. Satellite-based monitoring sounds a lot more palatable to people than GPS human tracker. So one thing we've tried to do in our work is to develop terms or words that are accurate, but which give the full extent and the full picture of what it really is. So when you have a strategy, you need to be including the smallest details, like the words that you use to describe things. Factors that I've seen over the past 25 years that have led to success and ultimately to positive change have been advocates who care about issues. So finding champions in your community, whether they are attorneys, whether they're friends or family, whether there's somebody at your legislature. Find someone who cares about the issues. You have to have advocates who know the law. There are many nuances in the registry laws. In fact, we have 50 different states with 50 different sets of laws. And there are even aspects and nuances of North Carolina's laws that I am not familiar with. That's why you need to partner with people that do know those nuances and are able to talk about them. Compelling stories. The story about my client who went to church is a compelling story. The story about Mr. Packingham, who was on Facebook to exercise his First Amendment free speech rights to talk about a traffic ticket. He had been to court for a traffic ticket. Those are compelling stories. Try to find compelling stories in your community and in your state, because those are the stories that legislators want to hear and that they need to hear in order to be able to convince them to change. You need to have a critical examination of statistics. This has become more and more important as courts are looking for statistics and information on which to make their decisions. One of the reasons that we have been successful in State versus Grady is that the state has never been able to put together statistics or evidence showing that GPS tracking is in any way working. Elected judges. Many states like ours have elected judges. That often means that they are not going to be willing to make a hard decision to let someone off the sex offender registry. It means they may not be willing to make a hard decision to find a statute unconstitutional. But you need to identify those judges, because the judges who will make those hard decisions are the ones where you might choose to bring your cases, because you might bring some of these challenges in state court. And then there's federal court, where judges are appointed and not elected. It still takes courage to make these decisions, but they don't have the political repercussions of an election that might get in the way of them making their decisions. So federal court is an area where we've had a good deal of success. And finally, regular communication between the trial and appellate bar and the advocates. I've noticed, at least in North Carolina, we have tried to have a good relationship with our trial attorneys, because those are the ones who are trying cases, and they're the ones who have the opportunity to set these issues up for appeal so that my office can take them through the appellate courts. So we constantly consult with them. We prepare motions for them. We prepare samples for them so that they can take those into court and litigate those to set up for us on appeal. So I've got a number of ideas for each of you as a champion to consider and think about, are these things that could be priorities for you? Are these short-term goals? Are these long-term goals? Are these things that we could bring to our efforts in our state? First is decreasing the revolving door involving technical registry violations. Second would be to continue to press challenges to restrictions tied to registration. Third would be to work to reduce the impediments, both legal and factual, to removal from the registry. Fourth would be to investigate and to work on racial disparities. And lastly would be to work on reducing registration for juveniles. So the first of those is trying to slow the revolving door. I have been in this practice long enough to have seen people who have been released from prison. They have a possibility of rehabilitation in the community, but they don't have a stable place to live. They suddenly have a charge of failing to register. And the next thing they know, they're back in prison for 3 years because they failed to register. And failing to register doesn't always mean that you're trying to escape or evade or not be found. The vast majority of cases involving failure to register that I've seen have involved people who simply don't have a home where they stay all the time. They might move to live with a friend or a family member down the street, but they're charged with not changing their address and failing to register. So the offenses that arise that are tied to the registry, the banishment offenses, the big brother offenses, those just give the state another opportunity to imprison a person. The violations are all technical in nature, but yet they result in imprisonment. And otherwise law-abiding people are caught up in this revolving door, having to go back to prison, get out, and that makes things even worse and makes them even less stable and able to have a place to live or to have a job. What I've also noticed with registry offenses typically is there's also no intent element. And by that, I mean, you don't have to intend to escape or evade or try to not be found. All you have to do is move next door into a different house, and you've committed the offense of failure to change your address, failure to register. You might have every intent of staying there and not evading the law enforcement, but they're still able to charge you because the offense doesn't have an intent requirement. The other thing I've noticed with these offenses is they tend to be enforced in an arbitrary and disparate manner. There are some jurisdictions, some counties, where the sheriff's deputy cuts someone a break. They might like the person. They might say, well, just get down there tomorrow and change your registration information. Other places have law enforcement and sheriff's deputies who don't cut anybody a break. They charge everyone the exact minute that they fail to register. And when you introduce discretion in a law enforcement officer's charges, you open the door for the possibility of discrimination for whatever reason. And arbitrary and disparate enforcement makes compliance difficult because people don't know what to expect. So I would ask you to consider, how can your organization try to slow the revolving door for people? Are there efforts you could make in the community to help people upon re-entry into the community? Continue to press legal challenges. As you heard from the ACLU in Michigan, they have a wide range of challenges to their statutes. North Carolina still has a wide range of challenges ongoing in our state. I think that Packingham versus North Carolina really gives us an opportunity to press harder on the legal challenges. The court in Packingham recognized the troubling fact that the law imposes severe restrictions on persons who already have served their sentence and are no longer subject to the supervision of the criminal justice system. That's the United States Supreme Court. Now, granted, Packingham was a First Amendment case, and it was dealing with someone on the internet. But when they said that, they did not limit what they said just to an internet restriction. They were troubled by the restrictions. So you could take that into your challenges for premises restrictions. There are still internet restrictions in some states, residential restrictions, GPS tracking. And I would ask that you also make sure that in your challenges that you argue the state and federal constitutions. In many states, your state constitution gives rights that are greater than the federal constitution, and you might be able to prevail in your state courts based on your state constitution. Improve chances for removal. I don't know what the process is in your state for removal, if at all. There are many states where once you are on the registry, you can never petition to be removed. In North Carolina, we have a petition process for a very small subset of people on the registry. Most people are on the registry for life, but there is a petition process for some people convicted of some offenses. However, petitions are rarely granted, and it's a very difficult process for a person to petition and be removed. So are there opportunities for change, to change the petition process in your state if you have a process? One idea would be automatic registry termination. North Carolina used to have automatic registry termination after 10 years. The person didn't have to do anything. It just stopped. Then they changed it and said, it doesn't stop automatically, but you can petition. Why not have periodic review rather than simply register for life? We all know that people change, and we all hope that people change, and that is an effort that NARSAL has taken on, is to help people to change. Why not have a periodic review rather than a simply registering for life? Also, helping individuals through their petition process. I've often seen in North Carolina a lot of people file petitions on their own. They don't have attorneys. They don't have anyone to help them. If they had done some planning and had some preparation and some help, if they'd had a champion, they might have been successful with their petition. But in North Carolina, you have to prove that you are not a current or future threat. That's a very difficult thing to prove. It's always hard to predict and prove the future. But with enough assistance, you might be able to get together a case to show why you are not going to be a future threat. So I would suggest, if your organization is able to partner with people to help them with these petitions, if you have these in your jurisdictions, it might help them make a strong case for removal. Discover and reduce racial disparities. I ran the numbers this week. In North Carolina, we have almost 26,000 people on the registry. Almost 60% are white, 34% African American, 5% Hispanic, 1.5% Native American, and 0.5% Asian. I can tell you that in North Carolina, our population is not 34 or 35% African American. It's more around 20 or 22%. There is a significant racial disparity in the people who are on the registry in North Carolina. I don't have any answers for why that's the case, but I can tell you those are the numbers. So what is it that we could do to work to change that? Well, first of all, continue doing what you're doing to reduce the opportunities for the state to put people on the registry. And then how does race impact removal petitions? If you have a state or a jurisdiction where a petition can be filed for removal. Studies have shown that bias tends to arise when actors are making discretionary decisions. And so I've never done a study in North Carolina. I don't even know where I would get the data, but it certainly strikes me as a possible area for research. Of all the people in North Carolina that have filed petitions for removal from the registry, what is the breakdown of the race of the people who have been allowed to be removed and the breakdown on the race of the people who have been left on the registry? I think that if we dug into those numbers, we probably would uncover some very uncomfortable findings. And support reform for juveniles. Juveniles, just like people of color, are also a marginalized part of our society. Juveniles in your state may have a different type of registry than those in North Carolina. Juveniles are treated differently state to state. In North Carolina, juveniles who are adjudicated for a sex offense in juvenile court may be added to a registry. It's discretionary. In some states, it's mandatory. But in North Carolina, if it's in juvenile court, it's discretionary. If the juvenile in North Carolina is added to the juvenile registry, they are not on it for the rest of their lives. They are removed once they become an adult. However, in some states, it is for life. We also, in North Carolina, will transfer juveniles into adult court. And that happens usually for 16 and 17-year-olds who are charged with sex offenses. Sometimes 14 and 15-year-olds are transferred into adult court if they're charged with a sex offense. If those juveniles are convicted in adult court, then they are placed on the adult registry, sometimes for life. There has been a lot of litigation in the courts, even including the United States Supreme Court, involving juveniles and life without parole. And what I'm talking about here are juveniles who have been convicted of murder. They've had their cases at the U.S. Supreme Court, and there have been positive cases from the U.S. Supreme Court which have said that juveniles cannot be sentenced to life without parole in prison without certain findings and without special procedures. So the United States Supreme Court has recognized that juveniles are different and that they should be treated differently. They're already treated differently with interrogations. They're treated differently with sentencing, as I mentioned, with prison sentences to life without parole. We did a study in North Carolina with regards to judges who were sentencing juveniles to life without parole. And what we found was that 91.5% of juveniles who were sentenced to juvenile life without parole are people of color or members of a minority group. That is a shocking statistic. But what it also might mean for you in your jurisdiction is that juveniles are also placed on the registry in a way that has been unfair. And lastly, is lifetime registration for a person who is a juvenile at the time of the offense even constitutional? I think in light of the United States Supreme Court's ruling that juveniles can't be placed in prison for the rest of their life, it might open the door for challenges to juveniles who are placed on the registry for the rest of their lives. So there are a number of emerging issues and areas for advocacy that I would suggest. We've talked about seeking success stories to share. You can engage people who are on the registry to help reduce isolation, because we know that community involvement and support reduces the risk of recidivism. We know that support groups help reduce isolation. Try to lobby for funding for counseling for people in prison and on probation, so that when they are finally out of prison or off of probation, they can ultimately be removed from the registry if that opportunity exists. And engage with partners who have common interests, the ACLU, faith groups, or the NAACP. I would also suggest for organizing or taking on issues in your state that perhaps you consider working to create some type of centralized indigent defense service. In North Carolina, we are very fortunate that we have a centralized indigent defense services that oversees our public defender offices, and it oversees private attorneys who represent indigent clients. It oversees my office, and it oversees the Capitol Defender's office. I've had contacts in other states where they don't have a centralized office or agency that oversees indigent defense. Everything is left to the town or the county level. What you would see in those states is a wide disparity in representation, especially in states that don't have public defender offices. So one thing you might consider in your state is finding out, do we have a central indigent defense services agency? If we don't, why not? Is that something that we could lobby for to try to improve representation for people? Because I can tell you that public defender offices are the best way to provide representation to people in court. That's not to disparage people in private practice. I've been there, I've done that. But public defender offices are the key to providing the best representation to people in court. If you have public defenders, you will have people who are guaranteed to fight for their clients and raise all of these constitutional issues that they can. So see what you can do in your state to work towards that. Lastly, I would say that champions persevere. This is a very difficult work that we do. Fighting the status quo requires constant chipping away at entrenched beliefs and prejudices. It's not something that happens overnight. We should look to other movements for inspiration. I was reading a book recently about the 1950s, about that decade of the 1950s, and I was introduced to Margaret Sanger. If you don't know Margaret Sanger, she was a woman who in the 20th century fought for the right for birth control. She started in the early 1900s to champion for women to have the right to birth control. It wasn't until 50 years later that the United States Supreme Court recognized the right of a person to have birth control. Margaret Sanger spent her entire life fighting and lobbying for something that she believed in, and it took her her entire life to accomplish that. This isn't something that we will accomplish overnight. One other thing that struck me just in the past 2 weeks about the work that we're doing that you might be able to take to your community, to your legislatures, and maybe even to Congress, is the current problems involving law enforcement. We all have seen in the news about George Floyd and his murder. It's really brought to the national forefront a conversation about the allocation of resources to law enforcement and to the agencies that enforce the law, and whether funding should be reallocated to other agencies to help people. So I would ask you, is this something that NARSOL or its allies could be a part of in the conversation about the reallocation of resources? Think where this could lead. Is this something where SORNA, the National Sex Offender Registration Laws, could be diminished in their scope? Could funding be returned to the states? Could it be reduced? Could states reduce their funding for their registries because they're draconian, ineffective, and too costly? Could those funds that were put towards the registry or put towards the SORNA be allocated to services that could help people rather than hurt them and give them chances of rehabilitation and recovery? And I don't know the answer to that. It's something simply that has come to me in the past couple of weeks as I've seen movements of people talking about reallocation of money to law enforcement and what good it might do if it were put to other purposes. So I would ask you, can NARSOL or its allies have a seat at the table in any of those discussions? And I'll close out with a quote that I found, that justice will not be served until those who are unaffected are as outraged as those who are. And I think that really exemplifies what it means to be a champion in this area of work that we do. We all have seen and we have felt the painful process of the registry. We have all been outraged at what it does. But at some point, those who are unaffected also need to share that outrage. And I feel that the people in our movement and the champions such as yourself are the ones that are able to do that. So I'd like to thank you for this opportunity to speak, and thank you for being an everyday champion. I'm also available
Go ahead, Glenn.
for questions.
Available for questions. Okay, if you had something else to say, that's fine. Thanks. I'm here to help you with the questions. And you hearing me okay?
Yes.
All right, great. We've had a few, and I'll try to keep an eye out for any more that come in. Let's see here. Let me start up at the top. First, just a quick thank you for using person first language. It's something that we try to do here at NARSOL as well. Much appreciated. That was the first comment that came in. We have a person that's asking if I had a GPS taken off my ankle nearly 2 years ago. Since then, I've had no feeling in my ankle due to nerve damage. And can I hold my state liable for that nerve damage in any way?
I don't know the answer to that. I don't engage in lawsuits involving damages related to the registry or the restrictions. So I would have to say you need to consult with an attorney who would do that kind of litigation. It certainly is an interesting question about how the GPS tracker has affected you physically. I just don't know to what extent that's something that could be the subject of a lawsuit.
Okay. Well, here's a nice North Carolina one for you. What is permitted in North Carolina concerning the internet, social media, etc.?
Right now, there are restrictions related to the internet, but what they involve are prohibitions against making affirmative contact with minors with some kind of bad intent. And they involve trying to disguise one's identity on the internet. So what they have done, they have actually created offenses that require some kind of bad intent or some kind of connection with the offense. I'd have to pull up the exact statute, which I don't have in front of me, to remind myself of what the prohibitions are. But they can be found easily on the North Carolina General Assembly website. But what it doesn't do, it doesn't have the broad reach of the prior law that was struck down in Packingham. So simply going on Facebook or on some type of social media platform isn't generally prohibited.
All right. We have someone asking, let's see here. Given that studies show that the brain doesn't fully develop until into someone's 20s, why are they putting some of these juveniles in an adult court system? Any clue?
Well, I think that historically General Assemblies or legislatures would figure out what they believed was the cutoff for adulthood. And most states now, that's 18. If you're under 18, you're in juvenile court. If you are 18 and above, you're in adult court. In North Carolina, we just finally caught up with that, and we finally added 16 and 17-year-olds to juvenile court. They had been in adult court until then. But we are still working on that. The U.S. Supreme Court, in their rulings on life without parole in prison, have said under 18, so 17 and younger, is what's considered a juvenile. We understand what you're saying in terms of the science of the development of the brain, and so we have been trying to push cases of people who are 18, 19, 20, 21 years old, and make those same claims as you're mentioning about the brain development, and saying, well, what's the difference between a 17-year-old and a 19-year-old? Why can't a 19-year-old be treated the same as a 17-year-old? So we are trying to increase the aperture so that we could have more people treated as juveniles. But at the end of the day, it's a policy choice that the legislature makes, or just a hard choice that a court has to make.
Right. We have a fellow here who says that he's been fortunate to be removed from the registry in the state that I'm assuming he lives in, but they remain on the registry in the state where the offense occurred. And he was wondering if you had any recommendations about getting off in another state where he no longer lives and obviously is not posing any danger because he isn't there. He's saying it would cost a sizable chunk of money to an attorney to do that and no guarantee. Any thoughts on that?
Not really, other than it sounds like you already are familiar with the process and that your best option could be to have an attorney. We've definitely seen that as a problem in North Carolina, where someone is from out of state, they're on a registry out of state, they move into North Carolina briefly, and then they leave and never come back to North Carolina. They're removed from the registry in the state of conviction, but then North Carolina keeps them on the registry. There's nothing I can say other than you simply have to try to be removed through whatever process there exists.
Yeah, and as he remarks, and I would echo that, there's really no guarantee, that it would be successful, of course, with the challenge. I don't know, let's see here. A person is commenting that it seems like everyone is offered plea deals with really long sentences or interminable sentences, anyway, that might last a long time. There never seems to be possibilities of trial. Most cases do go to plea deals. So what can we do about that? Is there anything we can do about that?
Well, one area of criminal defense or criminal reform that I would like to see, and that we always talk about in North Carolina, is reducing or consolidating the number of crimes. And let me give you an example. In North Carolina, if you have a gun and you try to shoot someone to kill them, you could be charged with two different crimes. You could be charged with attempted murder, but you could also be charged with a felony assault. And you could get 2 consecutive sentences for pulling the trigger one time. It's the same with many of the sex offenses in North Carolina, where you could be charged with multiple offenses for the same act. And that often in many states is the same thing. And that often is why people are pressured into taking a plea deal, because if they don't, they go to trial, they might have 3 or 4 consecutive lengthy sentences, where if they take a plea deal, they might have 1 lengthy sentence. And so one way to try to mitigate that is through criminal justice reform, where you try to eliminate or consolidate offenses that overlap and punish the same conduct.
Yeah, okay. We've got a situation here which we hear about a lot, which is where a person is removed in one state, but of course the underlying conviction's still there, and then they move to some other state, and in the new state they realize that the person still got that conviction and put them on a registry. And the question, of course, is can that be challenged in some way? I think
Yes.
I know the answer to this, but go ahead.
Well, yes. In fact, Paul Dubling won a challenge in North Carolina under similar circumstances just in the past several weeks. In North Carolina, if you come to our state from out of state, there is no judicial process for putting you on the registry. And there are some offenses from out of state that North Carolina doesn't have. And so a sheriff's deputy is basically looking at your record and saying, okay, based on my reading of the record, you are supposed to register. If you don't, I'm going to arrest you and charge you with failing to register. And there's never a decision by a judge that your offense from the out-of-state conviction is the same as one from North Carolina. Paul Dubling challenged that, and he won in federal court. I don't know if the state's going to appeal, but the federal district court said that was unconstitutional because there's no due process. There's no process at all, they said, to put you on the registry other than a sheriff's deputy saying that you're supposed to be on it. I don't know if that was the exact question that was asked, but that's what I took from it.
Sure. I'll add, since I hear this question often, in most states, the due process never really comes up. There just is a statute that will say, if you've got this conviction, you will be at this level when you move here. And there really isn't any way to contest anyway. There's no due process involved because it's written into the statute that way. So in most instances, I'm not aware of a challenge, but I'm not the attorney. So but that's frequently the situation people are faced with. They think that because they're off in state one, they can stay off when they move, but it's not the same as getting done with supervision. So it is an ongoing issue for most states. I don't know if you have any further thoughts on that, but that's
No.
the situation we've got. Yeah. Let's see here. North Carolina recently passed Senate Bill 199 that created a new high-risk category that prohibits a significant number of registrants from using the registry. So how will public defenders in North Carolina be able to address openly in court due process of being labeled a high-risk offender? Sure if I understood that, but maybe you do.
Right.
The bill.
I am not familiar with that.
Okay.
I don't know.
Okay. Yeah, it's new, I guess. We'll pick it up at a later time. A lot of churches don't want people on the registry or have rules like the person has to sit next to the pastor because of insurance and bias. And in addition, probation often doesn't allow people to go to church until after the first polygraph. So is there something that can be fought on that? Is there a way to fight this?
Well, I mean, as to the church itself, I would say that probably nobody is going to win a lawsuit against a church that says that you can't attend their church. The challenges that we've made have been against the state and against the statute, which makes it a crime. So whether the church is discriminating against a person or not, I probably can't speak about that because I don't practice in that area of law. But if a probation officer is stopping a person from going to church, then that is some type of interference by the state in the person's ability to exercise a First Amendment right to go to church. So it certainly could be subject to challenge. One of the things that we've seen with our litigation on this is that a lot of times the courts will make a distinction between people who are on probation or parole or people who are not on probation or parole. And at least in State versus Grady, that made a big difference, that our client was not on any type of supervision. So you also have to consider that and factor it in as far as your challenge goes. When we did our challenge involving the premise restrictions here in North Carolina, nobody was on probation or parole. They were simply on the registry, and that was the reason for the restrictions against going to church.
Okay, we're coming into the home stretch. We've had a few questions come in that have tended toward the personal. They've got a question about more specifically about a particular case that they're involved in. Is there a way that people could reach out to you, or another suggestion you might have about who they could reach out to?
If they're in North Carolina,
Yeah,
certainly.
North Carolina.
Yeah.
Right.
Yeah, certainly an email to me and Brenda. Is that something you could have in the materials that you pass to
I can, yeah.
participants? Okay.
Sure.
It probably would be easier than me reciting it over this video. But if you could pass that to participants, yes, especially if you're in North Carolina, I'm happy to at least give you some guidance on who to contact or where to turn. Folks from out of state, I am always happy to collaborate and to try and establish new relationships. So feel free to email me, but like everybody else, I've got a lot going on, and I'm not sure to what extent I can respond, but I can at least acknowledge that you wrote to me.
Sure, and that's obviously, attorneys are busy everywhere, and that's to be understood. Yeah, we'll get that information out. We've also, all through all the day, we've had questions about, hey, can we see the slides? Hey, how are we going to get this information? And we'll be sharing those slides with everyone afterward. So Glenn, I just want to give you a final thank you. We appreciate your being here and sharing your ideas with us. And we'll have to think about those pointy questions you had at the end for how NARSL can get involved in stuff. So much appreciated.
Thank you very much.
Thank you. We'll